Hello, everybody. Hello, C-Rex. Hello, Nana Laura. Hello, Eileen and Carlin. I hope you enjoyed your little cat nap. Hello, Lisette Bennett. Hello, Wire Mother. You made it at the beginning. Me either. Hello, Manuel. I'd certainly appreciate it. Thank you very much. Oh, those are the best. I get to nap with Ava on me. A little bigger than a cat. Just a wee bit. She does know move over, you know. That she has learned that one. She gets more of the bed than I do. That was quick. It's the bacon, egg, and cheese ones. It's 37 here, but it's it feels like 42 according to the weather thing. Oh my gosh, that's shorts weather. That is like sleeveless and sunshine. It was warm enough that my handicap ramp is almost cleared off from all the snow. And I did take the solar powered cat blanket pads and put one of them in the cooler and put the solar panel up. It hasn't sucked up enough UV juice yet. But hopefully tomorrow the sun's out and bright, and hopefully it gets enough UV juice. I'm getting jealous. Ooh, make you jealous. I got diesel coffee. It's the stuff from Charlie, and it's mighty fantastic. It's so good. I love coffee so much. So tonight we have 2 cases from today. One of them is in CTAC, which almost never runs virtual court anymore. So I was super excited to see them. And then the other one is from Connecticut again, but a different city in Connecticut. And then the last one is from the archive drive. I got Judge Mogan from 2023. Oh. Maybe it's the January thaw. I don't know. Hello, she's a maker. So we're going to have some fun tonight. We're going to have loads of fun.
And we are ready on Lavonda Simpson, Your Honor. This is 5A. This is 5A077963 here for Raymond. Is Lavonda Michelle Simpson your true and correct name? Ms. Simpson, is that your true and correct name?
Yes.
And your date of birth is February 17th, 1986?
Yes.
Earlier, we discussed your right to arraignment. Did you have any questions about your right to arraignment that I was not able to answer?
And can I ask a question? Who's this person named Kay? What does that person do?
That's one of the court clerks or one of the court employees.
The clerk, her name is Ruth.
Yes, and Ms. Kawasaki is also with the court.
And this name Cynthia, I'm not.
That's the prosecutor.
I'm not cool with that.
The prosecutor gets to be part of this proceeding.
Who is she?
The person who's filed the charges in your case for the city of SeaTac. But
yeah, I'm not. The reason I'm not cool with that name is I have this thing going on with a couple of different people, and that one of those names are involved in it. Okay. Like they've been tapping into like people's computer, and it's a program called Have you heard of it?
I have not.
It's for mental something, and they've been tapping into like my phones, my computers, and everything, and they been getting me like kicked out. And this lady named I don't know if it's Molly, Holly, Bella, whatever her name is. She's been she works for the police station,
And
it's just been a whole bunch of different things been going on. And
all right, Ms. Simpson, we're gonna proceed with the
go
arraignment.
ahead.
Okay. And Your Honor, I understand that the court might have some concern. I don't see any other cases where it's been raised. At this time, we're just asking I've gone over the charge, I've gone over the penalties, we've acknowledged the complaint, wait for a reading, ask them to plead not guilty.
If not guilty, will enter. I do find probable cause to detain. What is the city's recommendation regarding release?
I don't.
Down the amount of $500 cash or bond at conditions including no contact with the Motel 6 and SeaTac at the address listed. Do you see believe the defendant will
why do you feel like I should be detained?
Hey, Ms. Simpson, this is not your time to talk. You need to be quiet. This is Ms. Chenweller's time to talk.
I want to go to court. I don't want to do video court.
Go ahead, Ms. Chenweller.
City does not believe the defendant will appear out of custody or comply with court orders or conditions. The defendant has 2 pending charges or counts.
No, I do not.
For domestic violence out of King County District Court from October of this year. It appears that $1,000 bond was posted on that at the end of October, and now we have probable cause for this offense. And from the report, the defendant was just trespassed from that Motel 6 on December 3rd and 6th, and then returned on this date.
Mr. Arnone?
Your Honor, I know Ms. Simpson's hoping the court will release her. She's indicated she would show up for court out of custody. I did update her phone number and she can get text messages and would like it in the future if the court when it gets up and running. She does not have a good mailing address right now.
I looked at your warrant activity, Ms. Simmons. You've had 2 warrants this year alone. I think the first one was the filing amount, but then there were 2 failures to appear. I'm going to follow the city's recommendation and impose bail in the amount of $500. Additional conditions that you attend all future court appearances, have no new criminal law violations, update your address with the court and DOL immediately if there are any changes, use only your true legal name and date of birth, and have no contact with the Motel 6 at 18900 47th Avenue South in SeaTac. Do you believe you'll be posting the bond, ma'am?
I don't have money to post a bond, and I have to get a hold of my boyfriend and all that to post the bond. And what's the bond? $100 to get out?
But 500.
But if you go through a bail bond, it's 100.
You'll have to work that out with the bonding company.
Okay, well, because I'm not paying 500, and I don't feel like I should have a bail. I don't go to jail, ma'am. I have no record, so I don't see where you feel like I deserve to pay a bail.
Well, I'm looking at your history and that's not accurate.
Ma'am, I just started getting cases, and that's a false case. It's about to end.
You've had cases going back to
To what?
2003.
Ma'am, 2003, it's 2025, love.
Right, I'm saying your first case was in 2020.
The court don't even look at my cases like that. What are you talking about? 2003 from 2025? Are you serious?
Yeah, you just told me I have no history. I'm saying you have had history since 2020, since 2003. I'm imposing bail in the amount of $500. We'll set this for an in-custody hearing on December 18th at 11. I will
wanna get
just try and
started right now.
preliminarily, if you do post the bond, you will need to screen for the public defender if you wish to have them represent you.
You know why I don't trust you as a judge? Because I just told you that I'm getting harassed and I've been trying to deal with something. I will put you underneath detained for a CSI case that I'm about to have. I mean, not a CSI, but intelligent for phones and stuff. Because if you are a judge and you don't know about the MIB for mental illness, that means you're not really like you're not up on your game.
The last thing I knew about MIB was it starred Will Smith, and it was a fantastic movie.
Who doesn't know about that?
I'm sorry, but that's your opinion of me. We'll see you back here on Thursday. Thank you.
So I'd get out. Bye.
Not unless you post $500 bond.
I'm not paying no $500 bond.
Okay, then we'll see you on Thursday
No, why not tomorrow?
because I'm setting you for Thursday.
Okay, well, as soon as I figure out how to get bailed out of here, believe me, I'm coming for you and you, because I know who you are.
Are you threatening me? On the
No, I'm talking about that lady right there. She works with somebody that I'm not getting along with, and I'm keep on telling you that.
Are you threatening her?
No, I said when I say coming for you, that means I'll see you in court. I don't threaten people.
All right, thank you very much.
Right. I don't want that judge.
All right, thank you very much, everybody. See you tomorrow. Thank you, Ruth. Thank you, Kim.
Thank
I
you.
thought it was Catherine.
Thanks, Your Honor.
You keep on switching up people's names.
Oh my. No, it was Cynthia to start, and it was Cynthia when you logged off. Hi, Ava. Yes, I know. I laughed. I'm sorry. Everybody see the big ol' sticking out her tongue that she gave the judge at the end there? Yeah. Hello, Squishy. Hello, Satpanat sweetie. I said hi to you earlier, but you must have said hi and then walked away for a minute or something. I don't mind saying hi twice. And I got my sweet Michelle Moreland. I'm so happy you're joining us, honey. Oh, did I get everybody? Yep. Okay. I got everybody that came in. Yeah, it certainly sounded like a threat. So guys, now this it starts after some words have already been spoken. But it starts where it starts. And what I gather from it is the Attorney General's office made a big boo-boo. And they're trying really hard to correct their big boo-boo. It's not going well.
Our office, with our office that was closed back at the end of October of last year, and our office closed both of his files, and just assumed that this case was gone for all of this time. And as a result, we have created one heck of a mess. I just found out about this, just realized this morning when I was going through. I assumed that there was some kind of a issue with discovery, with proceeding against the other defendants not represented by the AG's office. And when I hit this docket this morning, it just went white. Absolutely mortified and embarrassed and ashamed of the mess that we've made here. And I'm prepared to address those. With respect to this individual motion, Warden Doran is now retired from the Department of Correction. I can accept service for him.
Okay. All right, let me just sort of back up to your general point. I appreciate the apology. I mean, there's discovery that was sent to your clients. I mean, I don't know how many months ago at this point. If I'm trying to go from memory, it may have been back in April. That was never responded to. There were many motions filed by Wilson Elser's office seeking 4, 5, 6 extensions of time, which were granted. The first 3 or 4 were granted until ultimately I denied one of their motions. And then there were motions for default against your clients, which I granted because there was no objection, no opposition. I mean, I understand what you're saying. There was another case, but I mean, you've been receiving, your office must have been receiving many copies of pleadings in this case. I mean, we're up to, we're on entry number 157, which I guess it starts at 100, but so that's 57, but there's also orders in between those motions as well. Like how did that happen that your office was receiving all of these notices from the court, orders from the court, motions from both the plaintiff here and the other defendants, and not doing anything with any of them?
Your Honor, first, I have no receipt of any paper orders of any kind. I have received emails that I just tuned out from the court and from the co-defendants because we were working under the understanding that this matter had been closed and the case was proceeding only against the parties that we don't represent. It was a horrible mistake for which I am responsible and for which I apologize.
Okay. What is the other case that was pending? Was that, do you know the docket number, or can you tell me anything where it was pending, anything like that?
It was pending in Hartford, Your Honor. It was Mr. LaPena. I can find it.
Okay.
It was LaPena versus Correctional Officer John Doe, HHD CV 23 507 7639.
That was 507 7639.
Yes, Your Honor.
I will
It was
take a look.
dismissed in June of 24.
Okay. I mean, this case, I guess, was filed in June of 25. You're saying that other case was dismissed in June of 2024?
Yes, Your Honor.
Okay. Oh, wait, I'm sorry. I just clicked on the wrong. Sorry. Got too many windows open on my screen here. This case was filed in April 2024.
Correct.
Or March of 2024. Apologize. Okay. I mean, I guess, you're going to have to file some sort of at this point, you haven't responded to the discovery. You've been defaulted. Okay. All right. Well, I guess we'll continue to go one motion at a time here. I guess on this specific motion, you've said you're willing to accept service on behalf of that defendant, correct?
Correct, Your Honor.
So, Mr. LaPena, do you have, I believe you have an address for Attorney O'Neill, because you've been sending copies of your motions to him, from what I can tell. Attorney O'Neill, the address he's been using on his certification is Hartford?
That is, Your Honor, but I think to be certain that I receive it, I think the best thing he could do is give whatever he wants to send me to his counselor and have his counselor email it to me. I think that's the safest way to do it.
Okay. Mr. LaPena, you understand what Attorney O'Neill is saying? Are you able to do that?
I do understand, and I am able to do that.
Okay. So I guess I will suggest you do that and then file something with the court to let us know that service has been made through Attorney O'Neill, who agreed to accept service on behalf of that defendant.
Okay.
Okay.
Your Honor, if I may just make a note here, the case
Yes.
that the Attorney General is referring to never went past very early stages due to improper service. Service was only made in the individual capacity, or no, official capacity, individual, and not in
Official.
the official, and not in the individual. So the case died there.
Okay.
But since then, I've sent dozens of notifications, certifications of the motions I filed to the office at that address, 165 Hartford, Connecticut, 06106.
Yeah, I know. I can see that. I mean, Attorney.
So another case was dismissed for lack of service. And now this case, the Attorney General's office is saying they completely dropped the ball on it. And what's going on there? What's going on in Connecticut?
Neil, I'm assuming you're receiving the notices from the court via email and maybe filings by Wilson Elser via email, but the plaintiff's filings, there are a lot of them, to be frank, those are getting mailed to your office. So I'm not clear on what happened with those.
Nor am I, Your Honor, except to say that, whoever is sorting our mail on a particular day is filtering for, I'm sure, what is a closed file, what has been recorded as a closed file, and something that I will address with the support staff when I get to Hartford tomorrow morning.
Okay. That, I guess, resolves that motion. It's sort of moot now because Attorney General is going to accept service. The next motion, 141, is the plaintiff's motion for a default judgment against all of the defendants. I think that was based on my prior order, I think, entering a default against them, which was then lifted as to the Wilson Elser defendants. As to the defendants represented by the Attorney General, I guess, we've heard somewhat explanation as to how the case got to this point, but Mr. LaPena, do you want to tell me anything more about this motion? Well, let me ask first, do you know which motion I'm referring to?
I don't, but I hear your language, and I think I have an understanding. It's probably the second default motion, which I think was just delayed, not having received your ruling on the first one. I filed another one, so maybe move.
Okay. All right, fair enough. The next one I have here is number 143. The plaintiff's motion filed September 20th is a request for inquest or hearing to determine award of damages to be ordered post-granting of default. And this was following up on my order granting the motion for default against the state defendants. I think you were saying in this motion that although you were grateful for the default, you're being prevented from getting all this discovery that you were seeking. So I guess what I was trying to figure out was, do you want to proceed on a hearing in damages, or do you want to get this discovery from the state defendants?
They have to be two separate matters or two separate choice.
I mean, if they're defaulted and there's a default judgment, we'd have a hearing in damage to figure out the amount of damages against them, as opposed to, but let me see, if Attorney O'Neill didn't show today or showed up and said, yeah, we did this intentionally, we were prepared to have a default judgment enter against us, then I don't know that I could order them to respond to discovery. I had already ordered them to respond to discovery and they didn't, and then I defaulted them for not responding to the discovery.
Okay, I think that at this point, there's substantial evidence against the defendants represented by Wilson Elser. Anything that I did or was able to obtain in addition to that from the Attorney General's office would be a bonus per se. I would prefer to move forward with seeking sanctions and defaults against the Attorney General's office for the conduct and how long it's been ongoing.
Okay, so you'd be seeking to have a hearing in damages against that defendant.
Yes.
Well, all right, Attorney O'Neill, I assume you want to be heard on this motion.
Of course, yeah, I'm going to ask for additional time, Your Honor, and an opportunity to provide discovery forthwith due to my error, my failings, and my office's failings in not properly managing this file.
I will say this. It's not often that you see someone actually take accountability when they say they're taking accountability. This Mr. Terrence O'Neill, this AAG, definitely seems absolutely horrified by closing that file incorrectly, not responding to any of the motions, and screwing up the case really, really big time. Because if that defendant filed a lawsuit against them for violating his civil rights, he'd win.
Okay. Okay.
What I would ask, if I may, Your Honor, is for Mr. LaPena, since he's providing things to his counselor, to provide the counselor with the discovery that he's looking for. He will email it to me, and we will get it done. Understanding that the holidays are next week, we will endeavor to get it all done within the next week.
I think the package might be too large for email. Knowing my counselor and the situation there, it's extensive.
Well, if it's extensive and it's copied, he can leave it at his correctional facility, and I can come and pick it up.
Okay.
It's the least I can do.
Okay. All right. So, Mr. LaPena, when do you think you can leave a copy there for Attorney O'Neill to pick up?
Only because of the holidays, I'm not sure how long it's going to take me to obtain copies of my original, but I would like to think that very shortly after the new year, maybe.
Oh, okay.
His counselor can email me when it's ready, Your Honor, if I can communicate.
That's what I was trying to clarify is, yeah, that's what I was trying to clarify. I didn't want to send you out there to pick it up if it wasn't ready yet. So,
okay.
Mr. LaPena, I guess to let your counselor know when it's ready for Attorney O'Neill to come pick it up.
Okay.
And then Attorney O'Neill will come get it.
I don't have a pen. I'm not allowed to bring pens down here. I'm gonna need your email. If maybe that could be sent to me, or
might be easier and more efficient if you just tell me the name of your counselor, and I will email him and communicate with him and tell him to expect all of this stuff. Is that helpful?
He's brand new this week. I don't know his name, but he is the counselor of IDORM at Cybulski CI.
That's all I need.
Apologize for that.
That's fine. Okay. All right. Next up is number 149, which was plaintiff's motion filed October 10th, a motion to extend time for discovery and request for status conference. I think you were, Mr. LaPena, you were just trying to get some rulings on some prior motions, I believe.
What that was I didn't know if I was gonna be cut short on time for the discovery that's at topic here with the AAG.
Okay. Okay. Is that, I don't think there's a scheduling order in this case. So what, I guess, what was there a specific deadline you were concerned about that you needed more time on?
No, just in some of my research and reading, it noted that in later stages of discovery, I might need to make a request for an extension. So I did so just to be safe.
Okay, that's fine. Is this for an extension for you to send additional discovery to the defendants or to receive the responses back from them?
For me to attempt to obtain the discovery from the Attorney General.
Okay. All right. So I don't know that I don't know that you need any sort of extension at this point. I mean, if anything, it would be the Attorney General's office would need an extension, but I don't know that you need one.
Okay, forgive me on that one.
No, that's fine. You're not a lawyer and you're trying to do the right thing by filing these motions. I understand that. That's fine. just make sure I've got the right. So 150 was Wilson Elser's objection to a motion for order. I apologize because I think that was an objection to one of the motions we talked about, 143, which was a request for the hearing. That was the request for the hearing and damages, and I think your objection was that you've now complied with discovery, you filed a motion for reconsideration and to set aside the default. I've since granted the motion for reconsideration and set aside the default. So as to your clients, I think that motion is probably now moved, and your objection, I guess, can be sustained. Is that correct?
Yes, thank you, Your Honor.
Okay. All right. Number 152 is the plaintiff's motion dated October 21st, 2025, which is the plaintiff's second motion to hold the defaulted defendant, AAG Terrence O'Neill, in contempt of court for continuing to disobey the court's discovery production order. And this is the plaintiff's motion laying out that he sent discovery over 6 months ago, filed multiple motions to compel. AAG's office has not responded. Default was granted. Anything else? Mr. LePen, anything else you want to tell me on this motion?
And just that, there was so many formal letters and motions for discovery and requests to compel through the court, and that I understand that the Attorney General says there was an issue with receiving things, but there was an outstanding amount of documents sent to his office
over the course of 6 months. Can you imagine waiting 6 months and still not having discovery for your case?
And an outstanding effort on my behalf via, direct correspondence with his office through the court, and the fact that Wilson Essler provided certification on their motions. The case that it is said to be confused with, it was over a substantial time before all of this was going on. That's a major confusion, Your Honor.
Yeah. Okay. Understood. Attorney O'Neill.
It is a major confusion, Your Honor. And what I would say is that, hopefully, in the spirit of my words and my deeds today, I have done something to convince the court and Mr. LaPena that we are on track with this case, that we will move it. I'm left to argue simpler things such as prejudice, and I fortunately don't see that Mr. LaPena has necessarily been prejudiced in this money damages case, which is not to excuse what happened here. But the Public Safety Division of the Attorney General's office has roughly 1,300 pending cases in state and federal court in the Claims Commission. I alone have over 70 cases in the various agencies and have supervisory responsibilities as well. And because of that, rely on subordinate staff to manage the caseload, at least the intake and the flow of paper, as we move for the most part to an electronic format. And while again, not looking to excuse anything, but more by way of explanation, and in an effort to convince the court and Mr. LaPena that we do everything we can to make this right and to get the information to him that he needs to prosecute his case.
Okay. All right. So, Mr. LaPena, I guess from your perspective, the good news is you're going to be able to serve the one defendant because Attorney O'Neill's accepting service. You're going to send your discovery, or you're going to provide a copy of it, which Attorney O'Neill will come pick up from the counselor. And he'll then respond to that discovery as quickly as possible. I guess I can enter an order, but from the date Attorney O'Neill picks it up, I guess he'll have, Attorney O'Neill, how much time are you looking for to have from the time you pick up the discovery to respond to it?
Ideally, I will take it straight or within the next day or so to my individual defendants and and crank it right out. I'm hoping to have it done within a week of receipt. I will make this my number one priority. I had a 2-week trial scheduled for the first 2 weeks of January that just resolved last Friday. I have open time, capacity, and will make this my number one priority, Your Honor.
Your Honor, if I
So-
may add one thing.
Yeah, sure. Go ahead, Mr. O'Connor.
The topic of prejudice, I think that, and it's not a tit for tat thing. I think I'm going to be prejudiced on this because I think that some of the discovery was video related, and it's going to be outside of the realm of what the DOC can provide on video at this time due to the extensive delays. Also, I spent 8.5 months battling to get off of methadone because of the conditions, suffering through it without any assistance, without any actually fighting them to allow me to get off of it. No medicated assistance to get off of it, nothing. And it was very difficult. There was definitely some prejudice.
Okay, understood. I hear you.
Thank you.
Yep. Okay. All right. So I'll probably enter an order saying from the time it's picked up, Attorney O'Neill's clients have 15 days to respond to discovery. I know you say you'll try and get it done within 1 week, but I'm trying to give you a couple extra days built in just to make sure it's done in time. And then I'll leave it to Attorney O'Neill whether any additional motions need to be filed at this point to excuse what's gone on in this case.
I honestly wish I had more details about this case.
And if those come in, I'll rule on them as they come in. Mr. LePenne, is there anything else you want to address today?
No, Your Honor.
Okay. Anybody else, Attorney O'Neill or Attorney Meyer, anything else that needs to get addressed today?
No, Your Honor. Thank you.
No, Your Honor. Thank you.
Okay. I'll enter some orders as discussed during the hearing today. And I'll hopefully that discovery gets to Attorney O'Neill and gets responded to as quickly as possible. And the case can proceed from there. All right.
Your Honor, may I just say one thing? Attorney O'Neill, there's a very strict thing with inmates contacting your office. So if in any case I have trouble getting them to email you or anything, I will send you a letter. Hopefully you receive it.
I've already reached out, if I may, Your Honor. I've already reached out to my secretary to get the name and contact information of your counselor, and I will make it clear to him or her that you're permitted to communicate with me through them by email or by phone call if necessary.
Okay,
In other words, I'll put in place a workaround of those restrictions. You're right. You're absolutely right. But there's always a workaround, right? I'll take care of that.
All right, thank you.
All right. Yeah, thank you, Attorney O'Neill. I appreciate that. All right. I think that addresses everything that we can address today. And with that, court will be in recess. Thank you all.
Thank you, Your Honor.
Have a good day.
Sounds like Connecticut has some things to work on. That says off.
We will go on the record in the matters 20 CF 256, 21 CF 56, 21 CF 177, 21 CF 202, 21 CF 274, 23 CF 171, State of Wisconsin versus Richard Connors. The state appears through Assistant District Attorney Kevin Schmidt in person. We have Glenn Keene, Defense Counsel, in person. Mr. Connors also appears in person in custody. We're set today in these matters for multiple things: status conferences, sentencing hearing after revocation, as well as a waiver of preliminary hearing. Mr. Keene, is that all accurate and correct?
Yes, and we have a signed plea agreement to close out 23 CF 171 as well.
What is the agreement that's been reached?
Okay, well, the agreement is that the state will modify the charge to endanger safety with a dangerous weapon under Wisconsin statute 941.20 1A. Let me I have to increase the print here. And he would serve 2 years of probation, sentence withheld, and no possession of a firearm until completion of a firearm safety course and programming as directed by DOC and costs.
All right. With regards to the 23 CF 171, well, this endangering safety, that would be, is it a class I felony?
That one's it's a class A misdemeanor.
It's class A misdemeanor. All right. So we do not need to have a waiver of a prelim if you're going to be modifying or asking to amend to a misdemeanor, correct, Mr. Schmidt?
That's correct.
All right, basis for the modification request.
I provided a picture of the firearm previously, right?
I don't know if you provided a picture, but I know you did discuss it either on or off the record, what it involved.
I'm going to show the court a picture of it because I think that's important.
I think it's some firearm that Mr. Connors was trying to.
It was my first deer rifle that I owned when I was a kid, and it survived a house fire when our house burnt when I was 14, and the barrel was burnt on the end. I was trying to make something of it because it was my first deer rifle ever from when I was a kid. And it did
learned
not
a
work
really
out.
good lesson, right?
Did not work out as the way it planned, but it was sentimental, and I wanted to make something with it.
Now you shot your finger, right? Where is your finger?
Just the tip of it.
Oh, it's just
Yeah.
it's
Oh,
just
yeah,
the
yeah,
tip.
yep. That's fine. So I'm gonna look up
Of
at
your fingernail and all of that.
It's growing back.
Well, that's good. Oh, heaven help me. Do not ever do that again.
Yeah.
It's gonna be a pistol.
Well, good thing we're not successful in that because it's also a federal crime too, as we discussed.
Yeah.
Yeah, so next time,
Get the permit.
no,
Leave it to the professionals.
or next time, put it in a nice, beautiful little display case. Put it up on your shelf.
Right.
And you won't violate laws and you won't shoot off your fingertip.
Yeah, because this.
So the reason for the amendment, I've actually had a very similar case in front of Judge Tolan where I did a similar amendment for the same reason. The purpose of the prohibition against sawed-off rifles is because rifles are considered by the legislature to be more often to be higher powered than pistols. And they want to prevent making higher powered weapons more concealable because there's not much of a legitimate purpose of making higher powered weapons more concealable, especially rifles. When we have a weapon like this, where you can see how the wrench was welded on to replace the lever action, the weapon was probably less concealable than it was prior to that alteration. So I think when looking at the intent of the legislature for the statute, we have a situation where the law is overly inclusive.
What kind of Franken pistol was this? The lever was replaced by a wrench. The barrel was burned from a fire when he was 14, and he was trying to saw the barrel off to turn it into a pistol, and he shot his finger off. Mess.
And that given Mr. Connors doesn't have a prior felony conviction, meaning he is normally able to bear firearms, I think that we can accommodate the public interest by getting a misdemeanor conviction, destroying the firearm so it's out of the community because it is clearly too dangerous. It exploded or misfired and injured his finger. And I think that this would be appropriate.
All right.
With this misdemeanor, we're allowed to do up to 2 years probation because there's a statute that says any misdemeanor involving a firearm allows you to do up to 2 years probation. So we have enough time to work with just the misdemeanor.
All right, thank you. Formal motion to amend.
So made.
It is granted. Now, before I proceed with any sentencing or sentencing after revocations or any pleas or anything like that, Mr. Connors, I believe you have your driver's license. There's just an issue with ignition interlock device and where they're being placed or whatnot, or did you take care of all of that?
I have to take care of that, and I haven't kept up on insurance being in here, so.
All right, and so that's one
So
thing that you're gonna have to
get it
do.
reinstated again, because as soon as I lose insurance, it gets revoked, and then I have to go through the process again.
Okay, all right, I just wanted to make sure because that was a process and Mr. Keen, it took
It is
Mr.
a
Connors
major
a
process.
very long time to get his driver's license, which he successfully did, and I was so super proud of him for doing that. And then one thing led to another, and I guess here we are again. But once you're out, you're gonna do all of that again, right?
Yes.
Okay, so we did a formal motion, the court granted that motion, it is now a misdemeanor, we do not have to have a waiver of a preliminary hearing. So with regards, let's start off by we'll do the plea, then we'll move on to the sentencings and do them in a bulk kind of fashion. Did you file the? You filed
Yes,
the
it's a
questionnaire?
document 11.
I have that. Thank you so much. So I have in front of me the plea questionnaire waiver of rights form. It appears that is your signature. Is that correct, Mr. Connors?
Yes, Your Honor.
And you are now looking at the document. Is that correct?
Yes, Your Honor.
Did your attorney go over this document with you thoroughly,
Yes, Your Honor.
word for word?
Yep.
You understand everything completely? Did your attorney go over your constitutional rights in detail
Yeah, we went through it.
and you understand them completely?
Yes, Your Honor.
Do you need me to go over your rights at all anymore with you?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
You understand that the recommendation here would be for the court to place you on probation with what's called a withheld sentence. Do you understand? I don't have to follow that.
Yes, Your Honor.
Said differently, I could sentence you to the maximum possible penalty. Do you understand that?
Yes, Your Honor.
Maximum possible penalty for this crime would be a $10,000 fine, 9 months of incarceration, or both. Do you understand that?
Yes, Your Honor. Could
And-
also go less, couldn't you?
Excuse me?
Said you could also go less, right?
I could go less, I could go more, I could do a whole lot of things, and you understand that I could do that. Do you understand? And
Yes,
you
I do,
understand
Your
that? Okay. Now, with regards to this crime, there are certain things that the state would have to prove your guilt beyond a reasonable doubt. And here it would be endangering safety by use of a dangerous weapon. Do you understand that the state would have to prove you operated or handled a dangerous weapon, and that you operated or handled that dangerous weapon? It would be in a criminally negligent manner, and that your operation or handling of this dangerous weapon in a criminally negligent manner endanger the safety of another.
Considering he blew his finger off, I'm gonna go with all of that.
It could be you, could be someone else, it could be anyone. Do you understand that?
Yes, I do, Your Honor.
And so you understand what the state would have to prove. Are you admitting here today that you in fact did engage in this type of conduct?
Yes.
And that weapon was not a safe weapon, the way that it was manipulated, or in the condition that you had it after the fire? You understand that?
Yes, I do, Your Honor.
Mr. Keen, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes.
Has anyone made any threats or any promises to you, Mr. Connors, for you to waive or for you to plead guilty to this crime?
No, they haven't, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing here today
Yes, I do.
and voluntarily?
Yep.
Has your attorney represented you competently?
Yes, he has, Your
Has
Honor.
he answered all of your questions?
Yep.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
Yep.
Any questions for the court or for your attorney before we proceed?
No, Your Honor.
As to the amended count one, endangering safety with a dangerous weapon, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count. Judgment of conviction will be entered today. All right, sentencing hearing after revocation. Both parties received the revocation order and warrant packet.
Yes.
Mr. Schmidt, any corrections or modifications of a material nature for the court's attention?
No.
Mr. Keen?
No.
And you went over that document with Mr. Connors?
Yes.
All right. Victims' rights compliance if needed, Mr. Schmidt?
Yes.
Argument and sentencing recommendation as to both the revocation as well as the new conviction.
Okay. I don't know that we came with like a joint agreement or global for all of them. I think we kind of more independently resolved both the sentencing after rather than this at the same time. So I'm gonna frame it like that. I think I want the 2 years probation on the negligent handling of a firearm because Mr. Connors does have a history. He has a history of misdemeanor offenses. He has a history of, kind of what I'd characterize as foolish choices. He's never really risen to a level of criminality that I'd say he's like a severe danger to the community. He's not out committing batteries or burglaries. He's not dealing drugs. He's not that kind of danger.
No, he's just gonna stupid himself to death or someone else.
The danger often is posed to him or people in his immediate vicinity from poor decision making. I think the 2 years probation can help deal with that. I think he's also got some substance abuse issues that could be handled there as well that are related. I think that the probation will also give us an opportunity for him to do some sort of firearm safety class. I think he likes hunting. Firearms are important to him, and him coming close here to getting his firearm rights restricted, I hope is a wake-up call to be more responsible about that. Because any felony conviction, any misdemeanor crime of domestic violence, any injunction by somebody could restrict his firearm rights, and it can happen very quickly. In terms of the actual sentencing after revocations, we actually both agree that to 7.5 months jail. He's already got an enormous amount of credit. The conviction he's coming for sentencing after revocation is essentially a domestic DC with attached bail jumps. So I think the 7.5 is already more than he would have got at the time of sentencing if he just pled out and the court sentenced him at that time. So I don't know that much more analysis needs to go into that given that fact pattern. So that's what I'm recommending. Thank you.
Mr. King?
Yes, and just for the math, understanding why, because the DOC's recommendation was 6 to 9 months, and realistically, by the time you got here today, it was after more than 6 months. By the time you figure in good time,
You probably should limit the math. We now have a clear view of what we're dealing with here. Keep it simple.
7.5 months, i.e. 225 days, that gets him out Christmas Eve. Because he had 151 days served counting today, and that would have him 18 left with minus 56 days of custody credit.
Is that 151 days, Joe?
Yes, is what he's already done, counting today.
All right. Mr. Connors, what do you want to say?
I just appreciate everything that my attorney's done for me, getting this felony taken off, because I am an avid hunter and everything. I understand I had to sit a little extra time because I didn't accept the first plea because it was accepting a felony and I would have got out right away, but I'm not gonna accept that. So if I have to sit here until Christmas Eve, to avoid that, that is not a problem for me. And I'm taking up your time.
Are you going to rethink some choices or think a little bit harder before doing some things? And you have been, Mr. Schmidt is right. Like when you're in here, other than there was an allegation, you were convicted of, I think it was a misdemeanor receiving stolen property, that skid loader or
Criminal damage property.
criminal damage. Thank you. See, you have a better memory of your conviction than I do.
Can you pull the microphone closer, please?
Oh, years.
Yes. So for that case was along a little bit, the most serious, I think, that you've been in front of me for. Usually it's operating after revocation and then some silly things. And I don't want to say silly because they're criminal conduct, the disorderly conduct, those kind of things. It's still criminal action, but of a less serious nature. This case, this action, this conduct could have been a little bit more scary. You could have lost your life. You could have been more seriously injured than just blowing off or shooting off the tip of your finger. Luckily and thankfully, it didn't shoot off more of your finger because it looks like it's mostly there. You said your fingernail's growing back and it's coming back. I'm just glad that nothing more serious occurred to you or to anyone else. I think that the recommendation is appropriate as it relates to both matters. You're still going to have some time if court follows a recommendation for the sentencing after revocation to still be punished and to still think about some things and where you're going to go and how you're going to plan your life. And then if and when you're released from custody for this new charge, and you're going to be put on probation, you'll have some time to figure some more things out and get your life back on track. Most important, other than the criminal thinking and getting your AODA, checked, is your driver's license. Getting all of those boxes checked, getting everything in place so that you have your driver's license and you can legally drive, because usually that's what
Gets me here.
yeah, that is. And then you're on bond, and then you have something else that happens, and then you get bond jumps and all of those things. And so it just spirals down. Because you were in a place, Mr. Connors, believe it or not, whether you do or you don't, I see it. You were doing so much better. You were on a really good path, and then you blew your finger off.
Mhm. Yeah.
So hopefully you can get back there, because I really want to see that. Okay. So with regards to the sentencing after revocation, I will follow that recommendation. 225 days in jail, 151 days of jail credit. Any fines and fees that you currently owe will be entered as a civil judgment. You're always going to owe those. You could sit up to 6 months in jail and have a warrant, and you know how I handle those and how that goes. So it's important that you continue to make your monthly payments. With regards to this new case, what I will do is I will follow the recommendation for probation. 2 years of probation. I'm not doing withheld sentence. You're going to know your punishment right up front. Okay, you're going to know what you're going to have to do. You're going to know that if you're revoked, what the penalty is going to be. It's going to be 6 months in jail, imposed and stayed. All right, so you're on probation for 2 years. If you get revoked, you're not going to come back in front of me. It's going to be a 6-month jail sentence. All right.
Okay.
And so the 151 days jail credit applies to 21 CF 177, or excuse me, 21 CF 21 CF 256, and 21 CF 56 to those cases. And with regards to this other matter, I'm going to give you an incentive, okay? I think you have cash posted. I need to check how much cash is posted. It looks like $250. Court will, with regards to this new matter, I will do $250, $200 DNA surcharge, $50 fine. I will waive the rest. I'm not going to assess the other court costs and fees. Or maybe you don't have $250. Can you check? I think he does, but I can't see if he does or he doesn't. No, he doesn't. Never mind. It's hard. My system doesn't see things that their system does. But the incentive here is that as condition, I'm going to put that you do the firearm safety course, absolute sobriety, you fully restore your driver's license and take all measures to do so. You do those 3 things, remain sober, you do those, those things, including the regular drug testing. I will allow you to discharge early off of probation. Okay, the earliest you would be able to discharge is after 1 year. So if you've successfully done all of those things and it's been a year on probation, you can then apply to have your agent to have an early discharge. All right?
Thank you, Your Honor.
So that's a good positive incentive because I know that it's not easy to be on probation. And that so that with the incentive, hopefully you'll do what you need to do. You'll take care of that. And it'll be good to go. So that could just be the old case. So what I'm going to do is I will assess the $250, $200 for the DNA surcharge, $50 for a fine and fee, waive the rest. Monthly payments, you're still making monthly payments, is that correct? And you're past due?
Probably. I've been in here. I barely got out, so.
So the court's going to continue your monthly payments. I can't recall if it was $50 or $100 a month, but they'll continue as they are. I'll add this on top of it. But again, failure to pay means you could sit up to 6 months in jail. The court could issue a warrant. I would also issue a civil judgment against you because you're always going to owe that. Again, the 151 days of jail credit as to the 2 other cases. 856. Very hard, quite honestly. I'm going to tell you, Mr. Connors, it's very hard when you have so many cases. I have to pull them up on the screen and know what we're dealing with. Where is that? There is this one. So is he still in a deferred, Mr. Schmidt?
Yes.
And what case is that?
Thought those were being thrown out.
Well, no, it's staying deferred versus the, just to make sure.
21 CF 177, 202, and 274.
So those are still going to remain in deferred status until the end of the agreement because there was a motion of entry entered on October 10. And so what are you doing? You're asking to withdraw your motion for entry of judgment?
Yep, the basis for the motion of the entry was the new offense.
So then let me just look at the deferred. Only be in one of the cases.
In 202, it's document number 34.
I'm seeing it. And it says 2 years from this date. So it would be October 2023, but
Oh.
it was stayed for a period of time. So for ease of everybody's knowledge, what does the state view that as then?
Probably done then, isn't it?
I would think it would be done unless you would like to, because it was stayed, which it was since filing of the motion for entry of judgment. There could be some months in there. It would take some thinking and talking but we would need something updated so we have an exact date and time. I'm fine if that's.
I don't think the DJOC, when it says, you know, we have up to 60 days, or I don't think that stops the time counting on the DJOC.
It does. It stays it. Once a motion is filed, it stays it until it can be heard.
I think that just means that it can't be closed out. Say if we discover something within 60 days after it's supposed to close, it would stay open until that's addressed with. I've never seen it interpreted to mean that the time stops counting when a motion is filed.
Well, then a whole lot of them should have been dismissed a long time ago. And that's for the office to figure out. But it was argued by one of the DAs that it stayed.
I don't know anything about that.
So that's fine. So then it is now vacated. It is now, those cases are dismissed. They're gone. So as to the 21 CF 177, 21 CF 202, 21 CF 274 dismissed on prosecutor's motion. All right, then that makes it all easier, Mr. Connors. So a lot more, a lot less to actually focus on, but focus on those few things here. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. We do need your DNA. The jail makes sure that we have that. You have the right to request it be expunged from the system. That was a written letter to the Department of Justice. You can either Google it or figure out how to, or ask your attorney. It's pretty easy to do.
Get his fingerprints. Get his fingerprints, Judge. Sorry.
Report to probation immediately. we're gonna send them a judgment of conviction, but give them a call and get your probation set up. Or quite honestly, it's not necessarily in effect until after you are released from custody. But if you give them a call, get it set up, you're all good to go. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Keen?
Nothing here.
All right. Well, good luck, Mr. Connors. And next time I see you, I hope you're walking in, showing me your good, valid driver's license.
It won't even be coming in here.
What?
Be on the outside or something.
We know what Mr. Connors is missing. He's missing the tip of a finger. Hi, Earl. Ava's over here snoring. I got Earl tapping on my leg. Oh, yeah. That was fun. Her surprise when she saw that gun. Oh my goodness. I know it would shock me to see it. Oh. All right, guys. I need to go figure out what's broken off of my van now. I think Ava tried climbing under the van, wrapped her leash around something, and pulled. There's something not attached. I don't know what yet. I don't know if it's the body. I don't know if it's a part. I just know it's a part from the van. So I get to go play with that for a little bit. So be safe, be well, sleep sweet, and much love.